Mr. Weber, you're charged with two cases. You're charged with assault of a family member. You're also charged with terrorist threat of a family or a household member. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Just so you know, I appointed you a lawyer yesterday. Your lawyer is here with you now. He is on Zoom. We're going to do probable cause now.
Judge, I don't know if you remember, we did probable cause yesterday. You found probable cause, unless you want to revisit it.
I do because I don't remember anything about it. And I want to be
Yes.
able to hear it with him so that we're all on the same page. Just real quick, if you don't mind.
No.
Okay.
On March 4th, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer met with the complainant and the defendant, who both stated that the assault did not occur. The officer then met with a witness who stated that he had
Notice how
multiple independent witnesses are giving consistent stories here. That's powerful for the prosecution. But here's the twist. Without visible injuries, the defense can argue these accounts are exaggerated. What do you think? Should witness testimony alone be enough to secure probable cause?
multiple independent witnesses are giving consistent stories here. That's powerful for the prosecution. But here's the twist. Without visible injuries, the defense will argue these accounts are exaggerated. What do you think? Should eyewitness testimony alone be enough to secure probable cause?
observed the defendant swing at the complainant 3 to 4 times. The officer spoke with the second witness who stated that the defendant opened the passenger door, punched the complainant 5 times, and when the complainant got out of the car, observed the defendant strike the first witness in the torso and shoulders. The officer then spoke with a third witness who stated that he saw the defendant strike the complainant 3 to 4 times with a closed fist and heard the defendant state he would fuck you up to the complainant.
Mr. Weber, I don't want you to have any contact with this person. Do you understand me?
Your Honor, if I may, after having contact with the complainant.
The judge isn't just laying down rules. He's making a bold promise. He will protect every single person in his county, no matter who they are. That's not just legal authority. That's a statement of moral duty.
Complainant in Sebastian form as well. We would be okay with no threatening and harassing.
No.
Yes, Judge.
No. I don't want you to have any contact with this person. And I want you to understand now that I'm going to protect every person in my county, regardless of who they are, what color they are, they're a small farm animal. Do you understand? Don't have contact with this person. If I find that you violate these conditions, if I find that you become a danger to my city, if I find that you pick up a new case, I'm going to revoke these bonds, and I won't let them hide. Do you understand?
Judge, if I may.
Please.
Judge, the CW was the one that came into court yesterday. She's a clerk for the Harris County. She's a clerk there in Harris County.
Again?
She's a clerk there in Harris County.
The complaining witness is a clerk here in Harris County?
Yes, Judge.
Okay.
She's the one that gave us those affidavits yesterday. You showed me.
I understand, but I've got. Go ahead. Go ahead.
She did not. She did not have any visible injuries. She states to me and to the district attorney that they were fighting over the keys, and that it was just that it was mutual, and that no injury occurred. She did not have any bruising again. She told that to the officer when she was arrested. Oh, I'm sorry, when my client was arrested. There were no visible injuries, nothing that would corroborate what the witnesses are saying.
There are 3 different independent, unrelated witnesses who see first 4 to 5 punches in the head, and then as he allegedly takes out of the car, these same witnesses see 3 to 4 punches in the stomach as well.
Again, Judge, if that were the case, we'd have some injury, Judge. We don't have any injuries that are noted by the police in the report, or by the CW when I saw her yesterday, or the prosecutor when he spoke to her yesterday, Judge.
Judge, from yes, that's what the children as well. Saying there were no visible injuries, no bruising, and that's why the review filed was very fast.
Come up, ma'am. I want to make sure that every single person here is protected, you know, and 99.9% of the time, I always like to follow what the complaining witness is, meaning you, what your wishes are, because, I really take that into account. I have to be honest that from what the witness's statements say, it sounds really, really just
This is a
aggravating.
turning point. The complaining witness herself is being asked directly, does she want contact with the defendant? These moments carry huge weight because the court has to balance personal wishes with public safety. What would you decide if you were in the judge's seat?
Aggravating and just, I don't want you to say anything. And so when I see something of this nature, it really takes me back. And that's why, I, there's a method to my madness and why I do what I do and to, protect you because I don't want something to happen to you. That's because you're the person I care about. What would you like?
I feel everything do not have to work even I am possible.
I don't want to talk about the case. I just want to know do you want to have contact with this person?
We deal with like things you guys are eating.
There is an order for protection that is in place now. I don't give a rat's behind what is going on. I don't care what stressors you have in your life. But if I find that you put hands on anyone, I will put my hands all over your bonds and I'm going to rip it. Do you understand? I don't care what's going on in your life. You put hands. It's really not going to go well. Number one. Number two, the court order that I have now, the order of protection, says that you're not to have any threatening or harassing contact with the complaining witness. I don't care what you think. It's threatening or harassing. It's what she perceives. So can conduct in and of itself violate this thing? Circle like this, is that threatening or harassing? It is, and it will land you in jail. Do you understand? I will do what you wish, but if I find anything happens in the future that hands are put, threats are made, I'm going to yank the bonds, and that's it. Okay? Um, so, you guys want to do it right now? I don't know if you've already done it, but okay. Come on, Jeff. So you mind filing no threatening, harassing, no weapons? You're not to be in possession of weapons as well. Do you understand? Okay. Take a seat for me while we get everything ready for you, sir. Good morning, Ms. Ford.
Morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed. P-O-U-R.
First, she's in the tow truck passenger seat, then suddenly back in her own car with the engine running. These contradictions are defense attorney's dream. Do you think the prosecution can clean this up, or is this case already too shaky to stand?
O-U-R.
On March 2nd, 2025, the officer was dispatched to an accident on the 4500 block Southwest Freeway. And it was passed out in the passenger seat of the tow truck. The officer noticed that her eyes were low, her speech was slurred, and her breath smelled like alcohol. She had also urinated on herself. The defendant said that she had one drink and was coming from a club. And the defendant showed lethargic behavior. And the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered. HGS was infused. walking turns to 8, one leg stand 3 out of 4. The defendant continues to harass, and the results were 0.128 and 0.11.
Where was she driving? What was she doing? All I know is that she's sitting in passenger seat of a coach. How did she get there? What happened? Was there an accident? Who is writing these reports nowadays? I mean,
Yes, Judge. The statement made a statement stating that she confirmed that this was her vehicle and she drove it to the crime scene. The defendant confirmed that she was with only her and no one else was with her. The defendant confirmed that she was on her way home from a club where she consumed alcohol. The defendant's vehicle was found stalled in the shoulder of a busy freeway, and the officer wrote that led the affiant to believe that I apologize, that there was no one else that fled from the scene. And the officer wrote from the affiant's training experience that he believed that the defendant was the driver of the vehicle, based on the statements made to them when finding the vehicle.
Wait, this is messy. First, she's in the tow truck passenger seat, now she's suddenly back in her own car with the engine running? These contradictions raise serious doubts. Do you think the prosecution can clean this up for a jury, or does this already sound too shaky?
did anyone see her drive? Tow truck driver see her drive? How long did she drive? When did she drive?
We don't have that information. There was Deputy Jim Pond was referred to a one-car minor accident, and the vehicle was sitting alongside the subject of running ditch. The defendant was passed out in the driver's seat with his hands on the ignition and the engine running. That's
So,
defendant.
so someone sees her in the ditch.
Oh, sorry,
In this case, she was passed out in the driver's passenger seat of the tow truck, and there's no other information in regard to her driving besides the statement she did. So there's no more than absurd. And we understand.
Let's do this. I'm gonna appoint you a lawyer today so we can have someone take a look at the case for you. Okay? Ramona, do you mind appointing someone from Ms. Board, please? Just do me a favor. Just take the seat from the jury box, will you, please? Okay, so it's a DWI Class B. Mr. Pons, please.
Yes, Judge. On March 2nd, 2025, the officer was dispatched to an accident call on the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck, and the officer noticed that her eyes were low, her speech was slurred, her breath smelled like alcohol, and she had urinated on herself. The defendant stated she had one drink and was coming from a club. The defendant showed lethargic behavior, and the defendant confirmed that she was the driver and no one was with her. Standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. Defendant considered the breath, and the results were 0.128 and 0.11.
We have her in the passenger seat of a tow truck.
Right. So statement alone isn't sufficient. That's all they have.
Your Honor, in the complete OR, there's further statements that kind of clarify the time period that when this happened. The officer stated that at 7:20 a.m., that's when he was dispatched to the accident call, and he arrived at 7:21. The defendant stated that she was on scene and she was coming from her residence from a bar called Good Mood that she had arrived at 3 a.m. And the defendant stated she had the one mixed drink only and left Good Mood Lounge at 5 a.m. when she proceeded to head home. And the officer found the vehicle on the right shoulder stalled, and the front passenger tire blown out. So the traffic or the encounter with the defendant took place 2 hours according after when she left.
So do we have an officer that actually sees her in the car in the ditch?
They are. The car just found in the vehicle with the tire blown out, and the only thing the officers have to put her in the vehicle is her statement saying she drove and when she left.
Well, that's it then. If that's the only thing they have, let's see.
Judge,
Their statement alone can't be sufficient evidence. They need corroboration.
And the corroboration we have is that when the officers arrived, there was nobody else on the scene. It's a crowded freeway. There was nobody else who could have gone to the accident or left the accident because they were on a highway with traffic and there were no other people around.
One, I don't see that the officers did any of that. Two, that's still not going to corroborate that she was driving.
Why are you saying that the statement, her statement in and of itself is sufficient?
That's a rule. I think you can't go on.
Yeah. I do.
Okay, well, give
So-
some time. Like,
Yeah. And I'm willing to, if you want, maybe like we can revisit on Monday.
Okay.
Because I want to give you time. I want to
Wait for her parents? For Monday?
Yeah, I'm going to put her under conditions. Yeah, okay. But I'd like to do a deeper dive on the PC, and I want to know, is that in and of itself insufficient? And it'll give you more time as well.
Just the
Let's
officer.
reach out Monday, and we'll do more, I guess, a formal hearing. Ms. Poor, we will have an additional hearing on Monday to determine whether there's sufficient probable cause to go forward. So you need to stay in contact with Mr. Pons, and he will tell you how we went forward on Monday. As it stands now, I'm ordering you not to consume alcohol or illegal drugs while you're on bond in this case. Do you understand? If I find that you consume alcohol or illegal drugs, I'm going to revoke your bond and we'll put you in jail. Did you guys run a license, please? And any other prior DWIs?
No prior DWIs, and we're running for a license right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive. Do you understand?
Okay.
Great. So for now, I'm going to have you sign a reset with Ramona. We're going to set it for Monday. You don't have to be here. No. We're going to waive your appearance, but Mr. Pons will let you know how everything transpires on Monday. And then after you sign the reset, I'll have you meet with Felicia if your bond conditions, and after that, you'll be free to go. Okay? Okay, Mr. Pons. Thanks.
Okay,
See you Monday.
So she needs to meet for bond condition.
Yeah, well, she needs to sign a reset. Mr. Crump, you are charged with unlawful restraint. You are facing up to a year in jail and or a $4,000 fine. We're going
This
to do.
moment hits hard. Now a child safety is at the center of the case. Courts treat domestic disputes involving kids with the highest urgency. Here's a question for you. Should the focus be on punishing the parents or protecting the child first?